John Trubisky presiding. Ladies and gentlemen, please be seated, and thank you.
Good afternoon. Before we get started today, I'm just going to give a couple of reminders to everybody in the courtroom. First of all, there are no cell phones to be used today here, no laptops. We like to keep all your electronic devices put away. Next, we need to keep it quiet in here. We need no talking, no disruptions, no outbursts. This is the opportunity for the parties to be able to be heard here, and so we really need to have order. Next, we just like for everybody to remain seated, not be up and down. If you need to leave, you leave only in an emergency, please. If once you've left, we're not going to allow you to come back into the courtroom. If there are any questions about anything, please feel free to direct them to our security personnel during the break. But otherwise, don't approach the bench or the witnesses, or there aren't any witnesses today, or the attorney to the bar. With that, so we are here today, as we all know, in the matter of Missouri Attorney General versus Kimberly Gardner. It's case number 2322CC00383. We got a number of motions to take up. Before we do so, I'll have the parties just announce themselves and the people that they represent, and we'll just, if we want to start over here on my left. For the attorneys, we are, this is being streamed live and recorded otherwise, and so if you could use this microphone here during your presentations, that would be great. For announcements, you can just go ahead and stand. Thank you, Mr. Jeffers. All right, so I think, yes. Okay, I'm sorry.
Judge Booker Shaw here on behalf of the judges of the 22nd Circuit.
Wonderful, thank you.
Your Honor, Bob Plunkett on behalf of Kyle.
Thank you, Mr. Plunkett. All right, we got everybody in? Wonderful. So I'm going to go through kind of the list of motions that I have to take up, and let me know if there's anything I'm missing. First of all, we have the motion to dismiss the original petition that's still technically pending. I assume that everybody would agree that that should be denied as moot at this point?
Yes, Your Honor.
Okay. Next, we have the motion to dismiss the amended petition, the motion to stay discovery. We have a motion to quash filed by the Circuit Attorney's Office, a motion to quash on behalf of Ms. Wilson Griffin, a motion to expedite discovery, a motion to expedite trial setting, a motion for leave, and then we have kind of the remaining requests from the motion for leave to amend and set a trial and schedule it for hearing, which I think mostly has been addressed. But is there anything else that anybody had a motion that they wanted to argue that we haven't taken up or haven't mentioned already? No? Wonderful. Well, unless you all think we should do it differently, I think that we should start with the motion to dismiss. Okay? Counsel?
May it please the court. Again, I'm Jonathan Sternberg, and I represent Circuit Attorney Kim Gardner. Your Honor should dismiss the amended petition in quo warranto that the Attorney General filed in its entirety. It's a poorly considered political move that doesn't remotely state a lawful claim for Ms. Gardner's ouster under the well-established law of Missouri. Under the only authority that the Attorney General has invoked, which is Section 106.220 of the revised statutes, specifically its subsections or subparts allowing for removal of a public officer for a, quote, willful or fraudulent violation of a public duty or willful neglect of a public duty. he has to show that Ms. Gardner intentionally failed or refused a duty. He omits that from both his petition and from his response to our motion to dismiss, which was filed yesterday afternoon. And, Your Honor, that's a fairly detailed motion or opposition, 37 pages long. I did not have time to file a reply in the last 12 hours to that. We'd asked for a week to file a reply. I'm an appellate guy, and as are you, and we're used to filing reply briefs, so I would ask for a week to do that.
Do you have any objection to the request for time to file a reply? You don't have to answer right now either, if you don't want.
Just another delay, Your Honor. They got 3 weeks to do their response to our lawsuit. We had a week to respond. We responded last night at 4 o'clock in the afternoon. I would, as we'll take up with our motion for expedited trial, we're asking for expedited trial, so I would object to another week.
Okay, thank you.
I'll address it as best I can. Perhaps we can take that up again later.
Thanks.
But he omits from both his petition and his opposition to our motion to dismiss that the standard is that he has to show that Ms. Gardner intentionally failed or refused a duty. His allegations, even taken as true, don't remotely come close to meeting that bar, which is why I guess he omitted that standard. You see, in our state, unlike in some other states, neither the governor nor the attorney general controls county prosecutors, or here in St. Louis, the circuit attorney. The governor and the attorney general usually are elected by the people of the state, and county prosecutors, or the circuit attorney here, are separately elected by the people of their communities. And every 4 years, they answer to those people, as Ms. Gardner did in the last election, where she won by 74%. Only a few years ago, in State Ex Rel Gardner versus Boyer, in 2018, the Supreme Court, addressing Ms. Gardner herself, stated that she has been elected to exercise her discretion to the dictates of her own judgment and conscience, uncontrolled by the judgment and conscience of anyone else. Despite this, in this case, our new unelected Attorney General, Mr. Bailey, has decided he doesn't like how Ms. Gardner is doing her job and seeks to unseat the people's choice. But because Mr. Bailey doesn't supervise or control Ms. Gardner, the law gives him very little room to seek that. And what he's chosen to invoke is 106-220. Again, it's standards of willful or fraudulent violation of a public duty or willful neglect of a public duty.
And that has been alleged in the petition.
Certainly. He alleges the words willful neglect. The question then becomes...
He mirrors the language of the statute.
He mirrors the language of the statute. That's correct. The issue in a motion to dismiss, of course, is whether not the conclusions, but the well-pleaded facts, the well-pleaded allegations meet the legal standard under the statute at issue. Here they don't. In our motion to dismiss, we cite what I thought at the time was the only 12 ousters in the history of Missouri under this statute. The statute's about 150 years old. I actually found another one while preparing for this yesterday. It's a case from 1954 where a county assessor solicited bribes, something intentional. Each and every one of those cases, though, were for intentional failures or refusals. The recorder of deeds who intentionally fudges numbers about the amount of money she received. Sheriffs who intentionally detain prisoners unlawfully longer than they know they're allowed to do so. Sheriffs who misrepresent costs and pocket the difference. County judges, what we would call county commissioners today, who direct that bond money go to their friends. And importantly, only 2 prosecutors in the history of Missouri, both in the 1930s, in the Wymore and Graves cases, who intentionally turned a blind eye toward notorious organized crime due to their own involvement in those same offenses. That's what it takes to make for a willful or fraudulent violation or willful neglect. Now, the most recent authority from the Supreme Court about this is the Foote case. They call it Fuchs, we call it Foote, from 1995. They note in Foote that these are 2 standards, right? Willful or fraudulent violation or willful neglect. Willful or fraudulent violation, the Supreme Court says, means malfeasance, that is, misconduct in the performance of official duties. Now, they, in their opposition, argue that we're focusing too much on corruption, and the word corruption has not been in the statute itself since 1945. But that portion, the malfeasance, misconduct in the performance of official duties, that actually used to be its own offense. If you look at the Olvera case, which both sides cite, and the Elliott case as well, both of those cite to an older statute that was repealed in the mid-1970s that was actually a misdemeanor where people in public office engage in some kind of official corruption. And if you had committed that misdemeanor, even if you weren't convicted of it, the law said in the Elliott case, then that fit that. In the Fletchell case in 1967, the Supreme Court refined, and again, this is after corruption is taken out of the statute, that what willful or fraudulent violation means are willful and deliberate acts of oppression and coercion designed to benefit the respondents personally and financially. Again, this is something they leave out of all of their pleadings. And then in Foote, the Supreme Court again said willful neglect, which is what they cite over and over again in their petition and their opposition, means, quote, the intentional failure to act contrary to a known duty. So what Mr. Bailey has to show to even proceed on this is that Ms. Gardner either committed willful and deliberate acts of oppression and coercion designed to benefit her personally and financially, or that she intentionally failed to act contrary to a known duty. The sorts of things that have only resulted in ousters before. Now, in his opposition, Mr. Bailey skips over this entirely. This is his opposition to our motion to dismiss. He tries to analogize this to the existing cases where someone was ousted for office, with him not identifying any new ones, but skips over that all the conduct at issue, all the conduct that was found to justify those ousters in those cases was intentional, and in the prosecutor cases was additionally in bad faith.
Aren't there allegations here, though, that all of the conduct taken by the circuit attorney was willful? Therefore, I can infer from that it would be intentional?
No, Your Honor. I'm happy to go through each of the counts, which I think might be prudent. In the prior prosecutor cases, the only two ones, Wymore and Graves, those were prosecutors who were accused of intentionally not filing cases against people, all right? In their opposition to the motion to dismiss, they argue that the other prosecutor cases, of which there are three others that we also cited, I'm sure Your Honor read, the Attorney General still got their day in court based on their allegations, so they should too. The difference there, though, is in those cases, once again, the allegations, the well-pleaded allegations in the original quo warranto petitions were for intentional failures to do something. So, for example, in the Wallach case, it's the intentional failure to file 95 liquor control cases that they specifically identified. That is not what they allege here.
But, I mean, if you changed the word willful to intentional in their pleadings, would you then believe that their pleadings were adequate?
No, Your Honor, because the only place the word willful occurs in their pleading repeatedly is in its conclusion, that they conclusorily say that Ms. Gardner willfully neglected some duty, all right? But what the well-pleaded facts leading up to that don't allege anything intentional by Ms. Gardner herself at all. They start in count one with an allegation about dismissals. And before I go deeper into that, I'll note that they, on page 52 of their amended petition, the Attorney General has a table of what he says are all the numbers of cases filed by the Circuit Attorney's Office, issued cases for the past 10 years or so. And if you add up all of the ones from 2017 through 2022, so that would be during Ms. Gardner's full tenure so far, that's about 19,300 cases. In their petition, in their amended petition, they identify only 40 cases out of 19,300 where they even allege anything. And in all of those, they don't allege intentional failures by Ms. Gardner. They start in count one with a complaint about dismissals. But all they have are 4 cases where someone else from Ms. Gardner's office made a mistake and the case was dismissed for some reason. Again, and before I go on with that, I want to make clear that Ms. Gardner does not accept any of these allegations. I think it's pretty clear from our lengthy answer that we dispute all of these allegations. Ms. Gardner is not throwing anyone under the bus, what Mr. Bailey calls in his opposition a pass-the-buck defense. That's not the defense. The issue is whether these allegations taken as true fit the statute, and the answer is that they don't. So they start by talking about dismissals, but no intentional conduct by Ms. Gardner. It's not like alleged, as was alleged in the Moody case in the 1950s, that she intentionally engineered the dismissals of these cases. There's no allegation of that. They then talk about noli prosequis in the second part of count 1. They point to 4 examples where there was a noli prosequi issued. Well, the fact that a prosecutor issues a noli prosequi, and again, all of those weren't alleged to be Ms. Gardner, they're alleged to be someone else. It's not that she's alleged to have done this intentionally.
Why isn't it a fair inference from what's been alleged that that this is intentional conduct, particularly when you take all of the contents of the whole entire petition together?
Because no actual, no conduct by Ms. Gardner is alleged to be intentional. It's not like any of the prior prosecutor cases. The noli prosequis, for instance, are much more like the Moody case, where the Supreme Court ultimately said that even an unwise or foolish noli prosequi doesn't rise to the level of this kind of intentional misconduct. It has to be the intentional failure of a known duty. So unless they have some fact that they can allege, which they don't, that Ms. Gardner engineered this for some reason, that doesn't meet that standard. That's not that high burden. The same thing with the failure to writ defendants. And I'll remind the court that in Foote, again, this is a recent decision from the Supreme Court, the Supreme Court says that the mere violation will not support a judgment of ouster. They have to show more than that, just that some duty was violated. They have to show that Ms. Gardner intended for that duty to be violated. And that's not something the court can infer because there's no extra conduct from which that can be inferred.
But is it your understanding, as it is mine, that the kind of the question of what conduct is intentional versus negligent or otherwise is typically a question of fact?
Once there have been allegations that meet that initial hurdle, they haven't met that initial hurdle yet. All they're alleging is effectively neglect by other people besides Ms. Gardner. That is not, as the Supreme Court confirmed in Foote, enough to allege an intentional violation of a known duty to subject someone to an ouster case. The same thing with speedy trial or failing to prosecute in associate circuit cases. What they're doing is they're plucking out select cases from 19,300 showing that something went wrong and then trying to say, well, now you should infer from that Ms. Gardner engineered that. There's nothing in their petition that suggests she did. So that isn't enough either.
What do I make of the allegations that all of these specific examples are part of a larger pattern in practice?
Well, they would have to show that pattern in practice. They, in their petition, they say that this includes but is not limited to. Well, you can't have any well-pleaded fact petition. This includes but is not limited to. You have to show your cards. You have to show what you believe fits this standard and what they've alleged does not. And even if there's some kind of extra pattern, that would be a pattern not, again, of any intentional thing. They don't get over the first hurdle of saying that Ms. Gardner has intentionally done something wrong. It's like the prosecutors with their friends in the gambling industry who, in the Wymore case, who doesn't want to prosecute his friends in the gambling industry.
Well, and a lot, those cases certainly are very specific. And I guess part of what I'm wondering is whether, that sort of conduct is necessary. I mean, it certainly is sufficient for an ouster, but is it a necessary type of conduct?
It is
the corruption, the I'm on the, the assumption that the prosecutor's on the take, that sort of thing.
Well, in the Wallach case, the Supreme Court said where there was no corrupt or lacking in, there was no evidence that the prosecutor was corrupt or lacking in integrity, nothing to show evidence of a corrupt motive. That was one of their reasons for saying that, well, so he didn't file cases against 95 people. Unless you can show that it was done for some corrupt intentional reason, then you don't get to the point of 106-220.
And that, again, I mean, in that case is a case that was done, that decision is made after evidence has been taken by a commissioner of the Supreme Court.
Right, but again, that was because their initial petition, if you read the Supreme Court's opinion, it recounts what the allegations were, was that he intentionally had done that for some corrupt reason. And of course, then it went to a hearing. What the Attorney General is lacking, I mean, they're the ones with the burden here, right? What they're lacking is any authority supporting the use of 106-220 in a circumstance like this, because none exists. We cited, and they certainly don't add any new authority, we cited every case where this has ever been done. They cite nothing where the subordinates of an officer were accused or alleged to have failed some duty with no allegation even that the officer herself knew about this, let alone engineered it, but the official was ousted. They try to use two cases in their opposition. Williams, which is from the Supreme Court in 1939, that was the sheriff cognate to the Graves case from Jackson County, and Orton from the Supreme Court in 1971, for the notion that a subordinate of the officer negligently failing a duty is enough. But that's not what happened in those cases. In Williams, and it's the Jackson County sheriff in the 1930s helping out the Pendergast regime, and the Orton case, which is the Pemiscot County sheriff in 1971, those folks were ousted, not because some deputy failed to arrest somebody, but because the sheriffs themselves intentionally failed and refused to enforce laws. The word intentional is effectively missing from their entire vocabulary. We addressed the standard. They don't address the standard at all, and that's the standard.
Well, the word intentional, though, is also missing from the statute.
Willfulness is intentional. That's what the Supreme Court held in foot.
And if they've alleged in their petition on numerous occasions that this conduct was willful, is that not the same as alleging on numerous occasions that this conduct is intentional?
If they simply had said this conduct was intentional as opposed to willful, I'd still be here arguing in front of Your Honor. Because, again, those are conclusions, not well-pleaded facts. And under the Missouri's a fact-pleading state. You can't just say, she intentionally did this. She intentionally, the way they phrase it is, she intentionally violated some duty, and then not plead any facts to actually show that she did. It's the absence of those well-pleaded facts that's what brings us here. If this had been something like in the Wallet case, where they alleged she specifically, for some intentional reason, did not file 95 cases against these individuals for some corrupt reason, then that might well be enough. But here, I'll note, despite arguing about discretion, the Attorney General doesn't actually argue that Ms. Gardner has refused. Again, it has to be some kind of actual refusal. It's an intentional refusal of a known duty. That's what willful neglect is, the Supreme Court says. They don't actually allege that she has refused to file any cases. In fact, in one of their counts, I think it's count 3, they say, count 2, that there's a backlog of 1,200 cases awaiting review and 3,500 pending warrant applications. There's no allegation that Ms. Gardner has refused. In fact, by their own language, they're pending. They're awaiting review. Maybe things are slower than the Attorney General would want, but the Attorney General doesn't control the office. And in the Wallet case, the Supreme Court said just because the Attorney General and the county prosecutor or the circuit attorney may have a difference of opinion about that does not make for a claim for ouster. I'll note, though, also, Your Honor, there are a series, and this isn't something we put in the motion to dismiss, but it's worth considering. There are a series of allegations in their amended petition that were from Ms. Gardner's first term and not her second term. I would submit that any allegation that was about something that was before 2020 isn't really properly to be considered. Because, for example, if the Attorney General were actually to win this, and Ms. Gardner were somehow ousted by the court, she could run again. The fact that something is alleged in a previous term, and I'll note everything involving the Xavier Uzanga case, those are allegations from 2019. That might be the only thing that comes close to arguing that or alleging that she refused to charge someone, although even then it doesn't, it just says she didn't. That's not enough. That's not a willful and deliberate act of oppression. It's not an allegation that she intentionally failed to act contrary to a known duty. The same thing with officer-involved shootings. They don't allege that she refused any of those. They allege that she merely, quote, has not made decisions about whether to issue or refuse charges. That's not a willful, intentional violation of a known duty, even taken as true. I do want to address, because a lot of their allegations, certainly the Sunshine Law allegations in count 7, the discovery allegations in count 4, the failure to keep victims informed allegations in count 9, those are all about Ms. Gardner's subordinates, and they even say so in their amended petition. In our opposition, again, we're not saying that any failings of the office are due to subordinates. Far from it. Ms. Gardner is very proud of her staff and the hard work that they do for the people of the city of St. Louis. The issue is whether those allegations are enough to oust Ms. Gardner, the allegation that someone else in her office failed in a duty. The Attorney General doesn't have any authority where that actually happened, where again, they try to do this with Williams and Orton. Those cases don't actually say that. Those are sheriffs refusing to charge people intentionally. What they do, though, is they try to use vicarious liability from other sorts of civil cases and try to, a respondeat superior kind of argument, and say that, well, if one of her if one of her staff does something wrong, therefore that inures to Ms. Gardner, and that is grounds for her own ouster. First of all, that fails the strict liability. That fails the strict construction of the statute. In Foote and all the other cases we cite, the Supreme Court says the statute is to be strictly construed. And it says if the person has willfully neglected a duty, has willfully or fraudulently violated a duty, then the person can be ousted. That's not an example.
And I come back, I guess, to the kind of the broad standard that we ultimately have here on a motion to dismiss, where I'm supposed to assume that everything in the petition is true. I'm supposed to make inferences in favor of the non-moving party here. And so, I mean, to what extent then, if they're alleging that, if the petition, specifically alleges that respondent did X, I'm supposed to, how do I get around that particular allegation to say, well, actually what they're alleging is that respondent's, superior subordinate did this?
Well, most of the time, the allegation is directly there in the petition, that it was an assistant circuit attorney who did this, or an assistant circuit attorney who did that.
Is the inference that it's fair that, if Ms. Gardner's subordinates are doing something, it should be at her direction, as opposed to, the opposite of that, like they've gone rogue, they're working on their own?
That's well, first of all, it's supposition rather than an inference. An inference has to be something drawn directly from a fact, not stacked on other inferences.
Well, the inference would be that if an assistant circuit attorney has taken an action, that it was taken in accordance with Ms. Gardner's duties.
Well, again, it would have to be that Ms. Gardner intended for that result, right? That's what they would have to argue. So the one case that they point to where there was something about a deputy, it's the Foote case itself from 1995. There, that was, actually, I take it back. It's another one of the, it's Nixon versus Russell. So this is the sheriff who intentionally failed to keep an inmate charged to his care confined in jail and let him out earlier. There, one of the defenses by the sheriff was, well, I thought that by my deputies doing that I was obeying my duty. But the difference there was, again, he intended for that to be the result. Here, there's no allegation that Ms. Gardner intended for discovery to be violated by her subordinates, that Ms. Gardner intended for people not to show up to court and therefore have cases dismissed, or any of the other 40 examples, or if that they come up with. There has to be that nexus. So there has to at least still be some intentional conduct alleged by Ms. Gardner, and they don't get there. But moreover, they don't even allege, if it were vicarious liability, it would be the same standard of intent against the lower officer as it would be against the higher officer, right? That one transfers to the other. They don't have any allegations that even the assistant circuit attorneys intended for bad results to happen in these, less than 0.2% of the cases that have been done in Ms. Gardner's tenure.
But if we're reading the allegations broadly, as as I have to do, isn't there kind of this general allegation from the Attorney General's office in each of these counts that there is a duty to do something, a duty to prosecute, and that Ms. Gardner has willfully neglected her duty to do so, and then their evidence of that is, that there have been a lot of dismissals. The number of cases that we're talking about. I mean, it seems that if we look at it really, if we get down into a granular level on all of this, it's harder than if we look at it at the allegations more broadly, as really I'm supposed to be doing on a motion to dismiss.
Sure. Their evidence of willful conduct is non-willful conduct. I mean, what they have to show is something more than that. In every single other ouster case, every single one where an ouster was successful, or where it went to a hearing or a trial or something like that, there has been a specific allegation about the intentional conduct of the public official at issue. Simply concluding that they willfully, intentionally violated some duty, but then showing facts that don't actually show that they willfully or intentionally violated a duty was not there.
Isn't kind of the mental state of someone necessarily something that you have to allege and prove by circumstantial evidence?
It certainly can be alleged and proved by circumstantial evidence, but they haven't alleged it. All they've done is stated conclusions. They haven't stated a single allegation against Ms. Gardner that she intended for any of these outcomes to happen. They have to have something more. They have to have the connection to organized crime, like in those old prosecutor cases. They have to have the young, inexperienced prosecutor who was letting his friend off with the nole prosequi, like in the Moody case. They have to have any of the other well-pleaded facts that were shown in these other cases, and they simply don't get there. The law of Missouri demands more. Just making conclusory statements that Ms. Gardner willfully violated or neglected some duty is not enough. Missouri's fact plead, that might work in federal court, but that doesn't work in this court. This is an attack on the democratic process by someone who was never elected. And if Mr. Bailey doesn't like the job Ms. Gardner is doing, that's his right. That's his First Amendment, his right under Article 1 of the Missouri Constitution, and he can support a different candidate at the next election and hope the people of St. Louis agree with him. But the law of Missouri doesn't allow him to do what he's trying to do here and use this court to oust Ms. Gardner for stuff that he disagrees with, not on these allegations.
Thank you, Mr. Sternberg.
Thank you, Your Honor.
May it please the court.
Counsel.
Mr. Sternberg and Ms. Gardner would like to talk a lot about what the petition doesn't plead, but she doesn't want to talk a lot about what's important under the statute, what duties she has failed or neglected. And there's a replete throughout the amended petition. There are assistant circuit attorneys not showing up in court and having cases dismissed out from under them. There are assistant circuit attorneys unprepared in court and nollying cases on the eve of trial over and over again. When we talk about 19,000 cases, if you add up all the case numbers during Ms. Gardner's term in office, the amended petition pleads that there were 2,700 cases dismissed by the court. A majority of those cases were due to Ms. Gardner's failure to either prosecute those cases, turn over discovery, or comply with speedy trial requirements. There were another.
I think, sorry to cut you off, but I think that let's get down to kind of the big crux of the issue, which was a lot of Mr. Sternberg's argument was, what's in the petition that allows me to make an inference that this conduct was intentional as opposed to just negligent?
Well, the Quo Warranto cases, contrary to Mr. Sternberg's reading, are replete with cases where the neglect of duty, willful neglect, is shown by when a public official knows that they need to do more and fails to do more. So the Olvera case was about a recorder of deeds who swore that certain financial transactions under oath were correct because that's her duty under office. And she argued that many of those entries, she did not know that they were wrong. And she changed one entry believing that she was correcting a mistake, that she was always acting in good faith. And the court granted summary judgment against her, finding that it didn't matter her subjective motive, her excuse for why she failed her duty. What mattered is that she was required to do more to verify that those entries were correct, and she didn't do that. That's what's going on here, and the petition is replete with examples that can show a repeated pattern of conduct that Ms. Gardner should have known to do more to complete her duties and failed to do more. That she should have known that her assistant circuit attorneys were failing to notify victims, failing to keep up with discovery, failing to try cases on time, failing to show up for court, failing to be prepared, and that she has to complete those duties. And the Williams and the Orton cases They're clearest evidence of this kind of conduct. So one thing the Quo Warranto cases have going for them is that most offices aren't as large as the Circuit Attorney's office, and most officers are more personally involved in their day-to-day duties. Obviously, Ms. Gardner does not try any cases that I know of and doesn't appear in court, but she is still responsible for making sure that all of those cases are prosecuted, for making sure that victims are notified, and for making sure that all of those things are done. Just like the sheriffs in the Williams and Orton case were allowed to rely on the local police to enforce the law in Kansas City or in the city that they lived in. But once they found out that the job wasn't being done, it's as if the police force doesn't exist. The sheriff has an independent duty to enforce the law when he knows it's not happening and he needs to do more. The same is the case here. The petition shows, beyond question, that Ms. Gardner should have known that she needed to do more, that her job was not being done, and in that case, it's as if her assistants don't exist. If they are not doing the job and getting it done, then she has to do more, and whether that's hiring more assistants, more effectively managing her office, or appearing personally to take cases. The duties of her office are her duties. They are not her assistants' duties, even when she delegates a task to them. Maybe the clearest example of this is in the Foote case, where the sheriff was accused in one of the Quo Warranto counts of filing a late report. He had a statutory duty to file a report on time. He filed it late. His excuse was that he assigned the case to a subordinate and they hadn't gotten it done on time. And the court said, that is a neglect of your duty. And while it's not enough by itself to show willful conduct, it was considered along with the rest of the Quo Warranto cases as evidence of neglect of duties. And the Russell case, Nixon versus Russell, is the same. There are repeated acts of neglect, and when they're added up, they show that the official should have known to do more and should have done more to complete their duties. And that's the definition of willful neglect. When you repeat a process that isn't working over and over again, your intentional failure to do more is willful neglect. That's what the case law says, and that's how the petition establishes it.
So I have one thing that I'm wondering about your petition is that there are 10 different counts. And part of my question is, you're asking for one remedy, removal from office. Are these counts independent of one another? Do they all act together? Some of them are like, well, maybe that one's not good. I can knock out a count here and there, or does one depend on the other?
They all could independently require the circuit attorney's removal, but the case law has a lot of discretion in the removal process. We give a lot of trust to our public officials, and a lot of times they get a lot of leeway. And that's why the Attorney General has discretion whether to seek Quo Warranto, as do local prosecutors. And this court ultimately has discretion to issue the writ if you think it's in the interest of justice or not. I forget the name of a case, but there was a case where an official was, quote, just for sometimes doing work that wasn't of the office while she was on the clock. And the court found that she fulfilled all the rest of her duties. There was no argument that she was doing a good job in office, and the quo wasn't appropriate in that case. But that won't be what the case is at the end of this case. The Attorney General, as pled in the amended petition, will show that these repeated failures to do Ms. Gardner's duty require it to be in the interest of justice to remove her from office.
Why is there an inference to be made from the petition that this was intentional dereliction of duty as opposed to just the way that Ms. Gardner decided to exercise her prosecutorial discretion?
I have two answers to that. So first, while Ms. Gardner would like the standard to be that she intended the ultimate result, that something bad happened as a result of failing to do her duty, that's not the standard. What ultimately matters under the statute is whether the duty was failed or the duty was neglected, whether the job was ultimately performed, and what the official knew or should have known about that, which the case law shows can be proven indirectly. But the second answer to your question about prosecutorial discretion is that most of the counts that we've pled here don't deal with prosecutorial discretion at all. Prosecutors don't have discretion to not show up in court for trial and have the case dismissed out from under them. That's not a discretionary duty. Prosecutors don't have discretion to keep victims informed of the status of their case. That's a constitutional right of those victims. It's not a discretion given to the prosecutor. Same with compliance with the Sunshine Law and the other statutory duties. While we have pled one sub-count of count one that's about Ms. Gardner's choice to nollie cases, and a couple sub-counts that are about reviewing and charging cases, discretion is not absolute. It's very clear from the prosecutor cases, both the two where the prosecutors were removed and the three where they weren't, that the court will look into the discretion in quo warranto cases to see if it was faithfully exercised, that using prosecutorial discretion is just another duty of the job. And like any other duty, it too can be misused incorrectly. Like the case, the third case where the prosecutor wasn't removed, it's slipping my mind at the moment, but in that case, it was one nollie and one decision to charge a defendant that they were talking about in that case. And they heard testimony from 10 witnesses and made the prosecutor explain his reasons for not nollieing the case. So it's clear from the case law that discretion is certainly not absolute, and just saying that I'm using my discretion is not enough to get around a suit in quo warranto. And so while we've
Could you
talked
address the question about you're not alleging necessarily that Ms. Gardner has taken any actions, but that her subordinates have taken a number of actions for which you're now trying to hold Ms. Gardner liable?
Yes, that's true, Your Honor. So we've talked about the part of the statute that's willful or fraudulent violation of your duties, some sort of personal enrichment or attack on someone. That's not the kind of oppressive act that we've alleged in the petition. Most of the counts allege that it was a willful neglect or a knowing failure, which as far as I can tell are pretty similar standards of proof. But when you talk about neglect and failure, obviously inaction is what we're talking about, not any particular action. And so the failure to accomplish the duty is what's at stake there. And it's clear that Gardner holds all of those duties. The Williams case says that a public official holds their office cum honore with the burden of all of the responsibilities of the office. And the Williams-Norton case made clear that dereliction of other officials or other people who have duties in the same sphere does not excuse an official's failure to do their own duties. So when we're talking about Ms. Gardner's assistants, their only duty under the statute is to assist her in accomplishing theirs. So if they fail to accomplish the circuit attorney's goals, the circuit attorney has failed. She directs and controls them, is what the statute says. So not only should you assume that their actions are under her power, that they're directly her actions, but we've pled, as a matter of fact and as a matter of statute, that Ms. Gardner directed and controlled her assistants in the course of their duty. So if they've done something in the petition, it's a fair presumption that it was at the direction of Ms. Gardner or under policies that she controlled that caused them to act in the way that they acted. And that extends to caseloads, of course. If you assign someone 500 cases, when you assign them the 501st case knowing that they can't possibly prosecute that case, you're not fulfilling your duties. If you give it to someone that in good faith could do it, then that might be a way to defend against a quo warranto action. But assigning cases to people who can't get it done because of the way you've managed your office is exactly the type of willful neglect and knowing failure that the statute is talking about.
How do we draw the line here between duties that are being done poorly versus duties that are being willfully neglected?
Well, in every individual case, a duty could be a failure. So, for example, in the Foote case, they had some number of cases where they were holding defendants for too long on bail. Obviously, sometimes they bailed defendants. Similar in the Wymore case and the Graves case, they weren't prosecuting gambling offenses, but they were prosecuting other offenses. They were carrying out the duties of their office. So if the duty was in one particular area, then you could point to, then maybe it would be limited to that area. But the circuit attorney's duties are broad to prosecute all the cases in the jurisdiction. So when her office shows up and fails to prosecute a case, it's just what it says. She's failed to prosecute. It's not discretionary to show up in court unprepared and to have the court dismiss the case out from under you because you're not ready. That's not doing your job. That's not just using your discretion. It's failing. That's what it is. And if you do it enough times and you don't take any steps to stop it, it's knowingly failing. It's willfully failing. There's no other result that can happen when you keep taking the same actions and keep getting the same results. And these patterns, as the petition shows, it's not as if it was isolated incidents. We've alleged a pattern spanning some 11,000 cases, and that's just dismissals and nollies. We're not even talking about, most of the counts don't even talk about cases that went to a jury verdict. We're mostly talking about failures before it even gets that far. So those cases don't involve the use of discretion when what you're talking about is doing the same thing over and over again and failing in a way that's not excusable. So that's the heart of our petition here, is that the circuit attorney's duties are hers, and they're not getting done. It's as simple as that. And the question is, does she know about that, and is there more that she can do? And we're going to prove that in several ways that are pled throughout the petition. These failures are public. They're known, like the cases with the prosecutors from the 40s, Wymore, Graves. Those failures that they had were notorious and open. Same here. There are cases that are matters of public concern that are going handled incorrectly, and that's as pled in our petition. There are patterns that span all of these cases repeatedly. That's like the Russell case and the Orton case, where they say repeated neglects of duties, even simple neglect, can add up to a knowing or willful neglect, a knowing failure to perform your duties. So the petition pleads those facts, and it pleads that Ms. Gardner directed and controlled her assistants in their actions as she's legally required to. And those actions that her assistants have taken or not taken, the court has to presume that they were according to a policy, practice, or direction of the Circuit Attorney's Office. If they keep doing something over and over again, then the case must be that it's been decided they should do it that way, or there's a pattern of failure that's never been fixed. And either one of those is willful neglect.
I mean, if I look at these allegations and I feel like, well, ultimately you're really just alleging, negligence on the part of the circuit attorney. That I don't think you're suggesting that would be enough to get us to even a trial here. That if it's genuinely negligence, if it's just she's not doing a good job, there has to be more than that. You'll agree with that?
I do. Certainly one act of negligence would not be enough, right? So if a circuit attorney didn't show up for a status conference, that happens. I think that's happened to probably every lawyer. Now, if I pled in a petition that over 11,000 cases circuit attorneys never show up at status conferences, that's a failure. You can't assume that was a mistake when the broadest intendment is given to the pleadings. A pattern in practice suggests more. And while we've only given...
The intention, I can infer intention, you're saying, because of the volume of alleged failures.
Yes, that's the Russell case directly. They say, while any of these one acts of neglect might not be enough to require their official's removal, repeated instances of this conduct are enough. So that's a matter of case law that intention in these cases can be inferred from repeated practice, and it must be that way because the statute is set up to protect Missourians from officials who knowingly and willfully over and over again fail them in their duties. It's not about honest mistakes. It's about a pattern and practice of failure, and that's what this case pleads, and that's what this case will prove at trial. Thank you, Your Honor.
Thank you. Mr. Sternberg, you have a response?
A couple of things Mr. Crane just said aren't correct. He said that the definition of willful neglect is when someone knows they need to do more but fails. That is not the definition of willful neglect. The definition of willful neglect is intentional failure to act contrary to a known duty. This notion that there are any cases where a public official was ousted from office, actually ousted from office because of repeated failures by their subordinates without any intentional conduct directing that by the official is simply not true. The Foot case...
It seems like there's some mention of a standard similar to that in some of the sheriff cases, particularly some of the ones with the, we thought the police were doing it.
The difference is, what those cases are about, I'm glad you asked that, Judge, those are about ongoing conduct, that the sheriff in those cases knows that ongoing there are these failures to obey duties by his subordinates. And he says, okay. That's not what they're alleging. They're alleging that there were past failures, that there were 4 cases that were dismissed, that there were 4 cases that were no-lead in some manner. But then they say that Ms. Gardner had some duty to do more with what cases that were already over, that wasn't ongoing conduct. That's what those cases mean. In every single one of these, and I'll note in Foot, which is one of the sheriff cases, that was a sheriff who misrepresented the number of police vehicles purchased for his personal gain. That's what ultimately really was his ouster. They said, yes, there's other examples of failures of duties during his time. That's not what actually got him ousted. It was detaining prisoners unlawfully and then basically stealing from the till. They haven't alleged anything like that of Ms. Gardner. This notion that you can show, so what if the circuit attorney's office, what if this wasn't St. Louis? What if it was Chicago, a really big city? And instead of, he said, if you show 11,000 failures, what if there were 300,000 cases a year and over the course of 7 years, they could show 11,000 failures. Does that show intent? I think it's proportional. Here you're talking about retrospective conduct. So Ms. Gardner sees that some circuit attorney didn't do their job, right? There's no allegation that she intended for that to happen. There's no allegation that she engineered that to happen. In fact, quite the contrary. What they're trying to do...
I think as I understand what their argument is that, well, the volume of things here should allow us to bring, that we believe that it's intentional as a result of the volume, and so ultimately, Judge, what we should do is have a trial and determine whether it is in fact intentional.
But they don't have that. They don't have any well-pleaded allegations of that volume. All they have are 40 cases out of 19,300. They say that, conclusorily, that 3,000 cases were dismissed, the majority because of some failure. Well, then show them. That's not a well-pleaded allegation. That's a conclusion. There has to be specific facts, and that's not enough. And I do want to mention, while I'm on that, Your Honor, you asked Mr. Crane whether the counts are independent or whether they're all interrelated. I would encourage the court. I mean, I think it's part of the court's duty in a proceeding like this to determine which of the counts actually, if any, do state this. And if the court finds, again, I would disagree, of course, but if the court finds that one or more of the counts are sufficient but others aren't, I think it's part of the court's function under the motion to dismiss rule that the court dismisses those counts that don't succeed.
Well, and actually that kind of raises an interesting question for me, which is, this is pleaded as a motion to dismiss, and I've already issued a preliminary order in this case, and so my question is, whether you think I should be dismissing the petition or quashing the preliminary order.
That's a very good question. So writ procedure is a little odd. I mean, I appreciate that. Rule, I think, 9806, which is about what happens after the preliminary order, is basically says that the preliminary order is a gatekeeping function, right? It's the court saying, I found that you have met the requirements of the statute and the rule, and therefore we're going to court. And the next step, I think it's 9806, says that we then have to file an answer and any other motion, and that the rules of civil procedure generally apply. No, I think the correct law on that is this becomes like any other civil lawsuit at this point. It's subject to, the only weird rule was we had to file an answer and a motion to dismiss. Ordinarily, I would have just filed the motion to dismiss and not wasted time with the answer until the time came if the motion were denied. But here, no, this is like any other civil lawsuit. It can go to summary judgment, it can go to trial, and it can be subject to a Rule 5527 motion to dismiss, just like we've brought. And I think the law on that's pretty clear. In fact, if anyone has violated the rules in this, it's the Attorney General by not filing suggestions in support of their amended petition, which the rule really did require. That might have enabled us to have a more cogent discussion about this.
Well, I mean, I guess they moved to amend the petition, but they had already filed suggestions in opposition with their original petition.
No, suggestions in support of their...
Yeah, well, sorry, I mean, but they had already filed suggestions in support of the original petition, then they moved to amend the petition itself, so...
The suggestions would, but that only applies to that petition, not the amended petition. I'm not saying that's a reason that it should be dismissed or stricken. I'm just suggesting that wasn't terribly helpful for the parties. One thing Mr. Crane said, and this is also something he put in his opposition to our motion to dismiss on page 11, is that there's an allegation that Ms. Gardner assigned cases to people knowing that they will fail. That's not pleaded in their amended petition at all. He just suggested that as well here, that she assigns 500 cases to a person knowing that they'd fail. I don't know about you, Your Honor, but I've seen plenty of public defenders who have 300, 400, 500 cases, and they seem to do fine.
They don't seem particularly happy about it.
Perhaps not, but it does happen. The point is that's simply that is not the problem with that is that's not actually an allegation in their amended petition at all. That she set people up to fail. That might be some form of intentional conduct. But the reason they don't allege that is they have no facts that they can allege that with.
Is that just a different way of saying that I think they have alleged that the circuit attorney has willfully understaffed her office?
Well, they say she's understaffed her office, that her office is understaffed, and then later they say that therefore she willfully failed a known duty. but there's no allegation that she intended to understaff her office. There's no allegation that she took some action that was designed to understaff her office. It's a hard hiring environment. I mean, there are all kinds of other reasons for that. But they have to show something more than something that could be inferred to be a mistake or something with which the Attorney General simply disagrees, which is what most of this seems to be, especially his argument or his count about the use of finances. There's no argument that Ms. Gardner was like that sheriff stealing from the till or like the assessor or collector in Olvera, actually changing numbers in account books. The allegation is that they don't like the way she spent some of her money. They wish she hadn't hired some outside counsel that she did. That's entirely within her discretion. There is no case law that says that isn't. And while we're on Olvera, Mr. Crane suggested that Olvera dispenses with the notion of intentional conduct because the collector there said that her conduct was mistaken. But she had admitted, and this is what got her ousted, which, I mean, her plain admission was resulted in summary judgment, that she intentionally had changed numbers in the books. And the obvious inference was she was taking in $100, only recording 10 and probably keeping the rest. But that, again, is nothing like the allegations here. They simply have no law that says what they have alleged, the sort of thing they've alleged, is sufficient for ouster. Ouster requires a great deal more. Our democracy requires more. We ask the court to dismiss.
Thanks, sir.
Thank you, Your Honor.
Any further argument? I'm set. Thank you. All right. So Mr. Sternberg, I'm going to give you 7 days to file a reply on the motion to dismiss, and then it will be taken under submission. My intention, if you get that to me in 7 days, is to have a ruling to you very quickly, though. You understand? All right. So then the next motion is the motion to stay discovery. I assume you still want to stay the discovery. Do you want to argue that?
May it please the court.
Yes, sir.
Judge, the issues with regard to the motion to stay are quite straightforward. As you can tell in this case, we believe that the allegations against Ms. Gardner were not properly pled. The discovery the pleading itself is over 620 paragraphs. The discovery we received to date is incredibly onerous, including there was an amended subpoena duces tecum filed and served on the CAO, the Circuit Attorney's Office, that has, I believe, 59 document requests attached to it. We believe it's appropriate, first of all, to make sure this case is going to go forward, and second of all, to know the scope of what's going to go forward before the parties actually start proceeding with discovery. We are very hopeful that this court will dismiss the entire case. If it dismisses even a large portion of the case, it will substantially reduce, hopefully, what discovery Ms. Gardner and, frankly, Ms. Gardner's employees need to respond to, and also, presumably, it will very much narrow what discovery Ms. Gardner will propound upon the Attorney General. So we just believe as a realistic thing that the discovery should be stayed until we know what pleading is active and what the scope of this case will actually be.
Thank you. Any response to that?
Your Honor, may it please the court.
Counsel.
There is no discovery that's taking place in terms of depositions until early May. We scheduled a deposition of the Budget Office. This court has never issued an order staying discovery. They allude to that, but this court has not. There's reasons for this matter to be expedited. We'll get into that in a bit. But I talked to Mr. Downey before this motion hearing. He told me he was going to argue that the motion to stay was subsumed within the motion to dismiss. I guess he's changed his mind on that. I would argue the motion to stay is subsumed within the motion to dismiss and that that motion is essentially moot. Thank you, Your Honor.
Thank you. I'll take that under submission. All right. I think we'll take up the discovery motions, and then I'll kind of do a general case management conference, at which point in time we can kind of get into the motions to expedite and those sorts of things. How about we do the motion to quash? Is everybody, Sherry, you okay? Yeah. Free? Yeah. All right, we'll go ahead and take up the motion to quash filed by the CAO.
Thank you, Your
Can you
John Jeffers on behalf of
clarify,
the
sorry, Mr. Jeffers, before you get started, can you just clarify for me who you represent, which of these subpoenas are still active and which ones you're trying to quash?
Yes, Your
Thank
Honor,
you.
I know there was a series of filings on this. We represent the Circuit Attorney's Office. There were several subpoenas directed at the Circuit Attorney's Office, and then there were also subpoenas directed at individuals employed by the Circuit Attorney's Office who I do not represent, but insofar as they are calling for office property that those employees only have in their official capacity, we would request or move the court to quash those as well.
Okay.
Your Honor, I think in the interest of judicial economy, I think the simplest position right now is exactly what Ms. Gardner's counsel just took, which is that we should await the court's resolution of the motion to dismiss to see whether the court will narrow the issues or dismiss the amended petition entirely, because a burden both on the court and on the recipients of the subpoenas to respond to this would be immense. And I think if the amended petition does survive, there could be further discussion with the attorney's office, there could be protective orders and so forth. If it's gone, obviously the immense burden of these subpoenas never needs to be visited upon either the employees or the office. So in the interest of judicial economy, Your Honor, we would say that we should just await the resolution and then come back at that time.
Okay. Have you had conversations with the Attorney General's office about what you would be willing to produce, or any kind of specifics regarding some of the, there are 59 requests in the most recent? Have you had conversations with the Attorney General's office, or has your position been we're not going to turn over anything?
No, Your Honor. We did meet and confer with the Attorney General's office just last week. They talked about a protective order. We said, look, if we're in a position where this case is still a live matter, then we will certainly engage with you on an appropriate protective order. The subpoenas that they have served are breathtaking, both in scope, but also in terms of the information that they would ask the Circuit Attorney's Office to produce regarding crime victims, regarding law enforcement informants. And we're talking information that is very, entitled to the most protection, and that is entitled to the most sensitivity, and that could only be produced with a very robust protective order. We've told them that, and I think we all put a pin on it and said, we'll meet and confer about this if we end up in a position where the office has to respond to these requests.
Okay. Mr. Corrigan, I see you shaking your head there. Would you like to address that argument?
The only thing I'd like to address is the misrepresentation that was just made to this court. There's no discussion, not a single discussion, about the Circuit Attorney's Office turning over any documents. We raised the issue of a protective order. We've been asking for documents since March 1. We don't have a single document, nor has one ever been offered. So what he just said is incorrect.
Your Honor, I think what I just said was that I said if this matter survives, we will meet and confer further. We did meet and confer before. Start looking at an appropriate protective order for something like this. But my position here is exactly what Missouri Rule 58.02E2 states, which is that upon an objection from a party, we would not have to respond to the subpoenas until further order of the court. And that's right there written into the rule. So if Mr. Corrigan has a problem with that, I think he has a problem with 58.02E.
Okay. Well, we're all here. You've flown in. The motion was noticed for a hearing today.
Correct.
Would you like to talk about it?
Well, Your Honor, if we do have to get into it, yes. I think, as I have said, what 58.02E requires us to state specific objections to the scope of the subpoena. The subpoena has many, and we have done that in our motion to quash. We've invoked numerous.
So I guess one of the things is you've kind of asserted a blanket privilege objection, and the problem that I have with some of that is that it's hard for me to make a really informed decision regarding what's actually privileged and what's not privileged, and what you need to turn over and what might be a closed record, and whether they're entitled to discover closed records, being as they do represent the state. So
Sure.
why is, I guess, I mean, there's been an objection made, and I question whether, how specific that objection was actually.
Well, Your Honor, if the amended petition survives the motion to dismiss, we would be happy to do what I do not think, what goes well beyond what the rule states, and go through each of the requests and say exactly what our objections are to each of those requests. There are several of those requests that, as I have noted, calls for information as sensitive as confidential, the identity of confidential informants, communications about witnesses, communications about victims who have done nothing other than try and put violent criminals behind bars. I mean, ultimately, what they are doing here by forcing the office to disclose that kind of information and the immense amount of manpower that would go into that is really undermining public safety. It totally defeats the purpose of what they say their amended petition is for. So, Your Honor, if we get to that point, if the amended petition survives, I'm perfectly happy.
I think that for purposes of our conversation today, that we should assume that the amended petition will survive, and if I decide otherwise later, I can enter an additional order, limiting the scope of what actually needs to be produced. But what I'd like to do is talk about some of these objections so that we can get this, show on the road, so to speak.
Okay. Your Honor, I mean, some of them call for, relatively non-controversial kinds of information, like an office organizational chart, some things like that I think if we were in a position where we had to respond, those things we could produce. Others call for information that are protected by a number of different privileges, a lot of which I've just alluded to. I think ultimately the court would have to litigate those issues. I think, for the purposes of judicial economy, it would be best to wait and see what the petition looks like.
Well, let me ask you this question. If I was to tell you to assume, that we have a petition that's filed, it's the operative pleading here, and that all of the allegations are going to stand, would you be in a position, there's a room across the hallway here, would you be in a position to go and talk to the state, the Attorney General's office, and whittle down some of what the issues are that we need to address?
If they're willing, yes, Your Honor.
Would you all be willing to do that?
Of course.
All right, well, here's what we're going to do then. I'm going to send you all across the hall. I want you to go through the petition and figure out what it is that you actually might be able to produce, what you have objections with, and then we can have a more informed discussion as to kind of the scope of what needs to be resolved, and what we need to put a pin in.
Okay.
Is that okay? All right, the court's going to be in recess. If you'll let the bailiff know when you're all ready to proceed, he'll come get me and we'll come back up.
All right.
Tell they're done. Okay.
Your Honor, did you have a time frame in mind?
How long?
Be respectful of the court's time.
How long do you? I got an office back here. I can keep plugging away. How much time do y'all need?
Judge, I'm hopeful we can get you an answer here pretty quick.
About 20 minutes? Is that okay?
Perfect.
Sounds great.
Let's do 20 minutes.
Perfect.
Ceremony courtroom will be in recess for 20 minutes. You may leave the courtroom, please. Ladies and gentlemen, make sure you leave something in your chair to identify your seat when you get back.